The purpose of this video is to provide a bit of insight into the process of buying property in New Zealand. Legal literacy, not legal advice. Hopefully you can pick out a few nuggets and otherwise enjoy learning a little bit more about the legal landscape in New Zealand. Enjoy. Well, welcome along, and to those online, welcome. Thank you for tuning in. Today we're going to be talking about purchasing property, and obviously particularly in Tauranga because that's where we are, but just generally in New Zealand. So my name is Simon Jenga. I'm one of the directors at LOA Law. We're a local law firm. We've got about 20 staff, and we do general practice, generally happy clappy law. But today is about legal literacy and just you guys being able to learn a little bit about how to buy property. So for those of you online, you're going to be able to see what we're going through. We're going to be having a chat in the room, and then at the end there's going to be a Q&A here, but of course you guys can just post your questions in writing, and then we'll look at answering them in the next week. So today we're going to go over the process of purchasing. We're going to look at the types of property, the types of ownership that you can have, specifically co-ownership structures. We're going to look at some of the compliance requirements, how to investigate a property, the conditions you might look at putting in, and a particular point is going to be buying when you're selling and how to make sure those agreements are talking to each other. And we're going to try and spend the majority of our time towards the end of those topics to get the most mileage. It wouldn't be a legal seminar without a disclaimer, so it's important to note that nothing that we're talking about today is legal advice, and that you should certainly talk to your trusted legal advisor before making any decisions. This is less about marketing and more about learning. So whoever your legal advisor is, if you already have one, you can see them, or of course you can come and see us at LOA Law. But specific legal advice about your circumstances is going to be the key. So the process of buying property, I deal with this all the time, so for me this is a relatively simple list of things, but this is the big picture. So we've got finding a property. You then need to negotiate the terms upon which you're going to purchase. You're going to sign the agreement, and either the agreement is going to be unconditional or it's going to have conditions. So if it's got conditions, you've got the opportunity to do further investigation before you're fully locked in. If it's unconditional, then you're locked in. So whatever's in that agreement, you are now bound by, and you have to complete the purchase of that property. If there's conditions, you're going to work through them, and then you've got the opportunity to either terminate the agreement or to go unconditional. After the agreement is locked in, we're then going to prepare for settlement, and there's a number of steps that we need to take at that point. So that includes making sure that your insurance is finalised, making sure that we've got the lending side of things and getting the money in, so whether that's money that you've got in the bank or additional lending. And then once we're ready to go, we're going to complete settlement. And that last point, that's where us as the law firm, we are doing the heavy lifting and handling settlement day on behalf of a buyer. Before that, it's a team effort with not only my client, but also with other professionals. So we've got real estate agents, we've got mortgage brokers or banks, we've got insurance providers. There's a number of parties that are having to kind of collaborate in order to get to that end point of actually buying a property. So the types of property that we're looking at. Now I've split this up into a couple of different categories. We've got property zoning, and I've put up there 4 different categories: commercial, rural, lifestyle, and residential. Now if we're buying a home to live in, then we're looking at residential, lifestyle, and potentially rural. And rural is just really covering outside of cities, and you're going to have a homestead area where there's the actual house and the surrounding area, which is treated differently than the rest of the property, farm, orchard, whatever it is. Forestry is another example. And so it will be treated differently, particularly in respect of its tax treatment. And so it can be really important if you are getting into rural and commercial property that you've got an accountant on your team as well to make sure that everything is as you think it should be from a tax perspective. For everyday people buying in the city, we're going to be looking at residential property. That's the key one. The different types of title that you can own. First is fee simple. Now this is basically where you own the land. So you just own a plot of land and that's yours, your name goes on it. Cross-lease is where there's a plot of land, and it was a system of subdivision that was developed kind of in the 70s, where basically subdivision was expensive and regulation was difficult. So instead of breaking up that piece of land into two genuine fee simple separate lots, the entire lot was informally, or I want to say casually, but that's not the right word. It was divided in two with two parties leasing to each other. So party A technically owns the whole lot, but they lease to party B this area. And party B technically owns the whole lot, but they lease the other area to party A. And then you have two separate titles for those two different properties. It's a style of land where you have extra relationship obligations with your neighbour than you otherwise would. That's the main point to get across with cross-lease. Stratum estate, which is commonly called unit titles, this was originally designed to cover land that is not land. So apartment buildings are a really easy way to conceptualise this. If you buy on the third story of an apartment building, you are not buying land per se. You're buying like a square of air, basically. So that's what the unit title or the stratum estate is describing, is your ability to buy something that's not necessarily the physical land, although it is on a piece of physical land. And then we've got the Unit Titles Act, which most recently has come in and formalised a lot of terms so that now that style of ownership covers a number of different ways of conceptualising property. An example would be a set of 8 ground floor units that are all connected with one long driveway. They might all be unit titles. And so all the owners have obligations to each other. There's one overarching block of land, and then each owner owns their little unit together with common access. So it's a style that's designed a bit more flexibility around particularly areas where there needs to be common access. The last one there is leasehold. And leasehold is where you don't own the land outright, you own the right to be on the land for a set period of time. A really good example of that would be in downtown Auckland. There's a lot of leasehold land that apartment buildings are built on, where there's a Māori land trust or other trust that actually owns the underlying land, and then that is on long-term lease to developers who then develop it, create leasehold titles, and then sell those. And so then the apartment owners in those apartments would own a leasehold interest in those properties. We also have some here in Tauranga on Totara Street, where there's some commercial leasehold lots, basically. For all intents and purposes, you own the land subject to a time frame. That's really the crux of it. And depending on the time frame, depends on the value of the property. So if you only have a 5-year leasehold, then that's nowhere near as valuable as a 100-year leasehold in terms of how you could sell it to someone else. These last two types of ownership are different than physically owning a piece of land, physically having your name on a title. Timeshares are not super fashionable these days. I don't think in the last 9 years I've ever dealt with a new timeshare arrangement. It's a bit of a historical structure. But syndicates are still fairly common, but more in an informal, closed syndicates, i.e. A small group of friends or a small group of business partners going in and syndicating a property together rather than large scale. And if you're looking at large scale, then you're starting to get into big funds where they own large commercial premises that you can buy into in a more structured way. Occupation rights is the last one, and that is really covering predominantly our retirement village ownership. So if you're buying in a retirement village, you're buying in a right to occupy. You don't actually own the land, and generally you're paying a premium at the back end for that type of ownership. And what I mean by that is that if you pay $1 million to buy in to a retirement village, when you leave, often in a box, then there's an exit payment fee, which if you've been in there for longer than 3 years is almost certainly going to be around 30%. And so then that's deducted, and then you get the balance back out. So occupation rights are not a way to make capital gains off property, or you don't get the value of capital gains. They're a way of giving people the right to occupy at a cost. Okay, so that's the actual property that we're buying. Now this is the way of owning, or who can own, more importantly. So first of all, we've got personal ownership. which is myself or a couple owning. And then you can own it in two different ways when you're personally owning. So you can either own it as joint tenants or you can own it as tenants in common. Now, joint tenants is where you own the property jointly. If something happens to one of you, then the survivor automatically gets that property. It does not go through your will. That's compared to tenants in common, which is where, let's say, two people own property, they own it together, but they own it in shares. So if something happens to one of them, then that half of the property is going to be distributed pursuant to their will. And their will might direct it to their kids or to their siblings or to their parents, but it doesn't necessarily go to the other owner of the property. The second type of ownership is ownership under a trust, which is very common in New Zealand, and we will at a later date, I think in a few months, we'll be doing a trusts basics seminar, so you can be on the lookout for that as well. But the crux of it is that the trust is holding it for the benefit of beneficiaries. The company ownership is the third on the list there, and partnership ownership. These are generally reserved for investments rather than owning your main home. It would be rare, I think, to own your family home under a company structure, and you would be more only doing that if you had some other purpose for needing a company to own that property. Maybe if there's a business operating on the land would be a reason to potentially do that. And we see that more in the agri and rural sector. So if it was a farm or an orchard, then it could be a what's commonly called a trading trust, which is effectively just a trust that is operating a business, or it could be under a partnership or a company that's actually running that orchard. The next on the list is constructive trust. Now, everything else on here, and I'm just going to skip that one for a second and come back to it, because estates are when someone dies and then that ownership falls into the estate of that person to be distributed under their will. Okay, now so that and the rest of them are all formal ownership structures. So they're all structures that happen because of what you have put in place, and in respective estates it happens by operation of law. Constructive trusts, they are imposed on land. So an example might be that I was working on a piece of land for 10 years and I was always told that I'd work on this piece of land and that it was mine 50-50 with the owner, even though their name is the only name on the title. I put in all the capital to develop the land, I put the sleep out in, whatever it is. It was always on the basis that I owned half of that property, even though my name wasn't on the title. Now, if my friend goes to sell that property and take all the money, then I would be trying to argue that he was holding half of that property on constructive trust for me. So it's a ownership that I'm trying to impose on the property rather than the property actually demonstrating that it exists. If you looked at the title of the property, you wouldn't see my name on it in that scenario. So it's more resulting from dispute or litigation, and when parties are trying to impose their rights on a piece of land. Now, that leads quite nicely, that little example, into the different types of co-ownership structures. I've got three headings on this slide: who, what, and how. Now, who, as in who am I going into this co-ownership structure with? It could be a friend, it could be a family member, or it could be a business partner. Those are the main three categories I think that we would see co-ownership models. And a really easy example, which I'm going to carry through here, is the bank of mum and dad. So mum and dad are going to contribute into the purchase of your first home or of your property, and then you're going to actually buy that property together. So maybe they're going to own half and you're going to own half. And so we come to the what, which is effectively, it's a what, but it's really a why. Why should you formalise the arrangement with your parents in that scenario? Or if you are the parent, why should you formalise the relationship with your child? Because what we hear commonly is, oh, they would never do X. They would never sell the property from under me. They would never demand that we upgrade all the plumbing. They would never stop us from adding a sleep out. Whatever it is, it always starts with they would never. And in my limited but 9 years of experience, when Often that's true, but when it's not true, it's really not true. And so having these structures in place protects people from those awkward situations. So the things that we're going to be looking at in that agreement are who's using the property and how is it going to be used. So in the example of mum and dad and child, is the child going to be the sole tenant? Or is the parents going to also occupy? So is there going to be a sleep out that the parents move onto the property with the child in the main home, or vice versa? So knowing exactly that relationship, that also kind of leads into who is responsible for what costs. So the utilities of actually living on the property, internet, power, water, but then also rates, insurance, things that are more traditionally associated with land ownership rather than just land occupation. That includes our improvements, our maintenance. So those things I listed off initially around adding a sleep out or updating the plumbing, who's responsible for those things? And then the bottom two where it's getting serious. So who and how can you dictate the sale of the property? Can one party demand that the property be sold? And if they can demand that, how much time do they have to give? So do they have to give 6 months notice if they want their investment out of the property? Do they have to give a year's notice? Or can they not give notice? So relatively common is if parents are putting $50,000 into a property and maybe they get an interest, that there would be a provision in there that the parents aren't actually able to demand that the property be sold in order to give some security to the kids that have moved in so that they know that they're not going to have to come up with that money unless they sell the property. But not everyone's in a position to be able to just park $50,000 indefinitely, $100,000, $300,000 in a property. So again, it's about making sure everyone's on the same page rather than it needing to be a specific way. And the last one is what happens if someone dies. So is the survivor able to continue to occupy the property, for example? So if it's, rather than family members, if it's two friends, can the surviving friend continue to live in the property for 6 months or for a year or indefinitely? That's important because the friend that's passed away, their parents or siblings, they might be quite keen to get their money out of that property. They might have plans of buying utes or going on trips, or just wanting to close out their loved one's estate and not have it lingering over them. It doesn't have to be a nefarious purpose. It can just be people wanting to move on. And that's probably the big takeaway for structuring co-ownership, is actually it's not always people being naughty that gets you in trouble at the back end of these situations. It's actually often just people living their lives. Two friends go in, they buy a property because neither of them can afford one on their own. 3 years later, one of them is in a relationship, they want to buy a home with their partner, but they can't because they've got this property with a friend, and so the bank won't lend them any more money. Or they need the equity out, they need the cash out to be able to buy the other property. So they're not being horrible, they're just living their life. So having a plan, knowing what the structure looks like, is going to help in those situations. In terms of the how, for a company, shareholders agreement is how we handle it. For tenants in common, which is just individuals owning property, two individuals, it's a property sharing agreement. And for a partnership, it's a partnership agreement. That's how we handle those terms, and we can just put in the terms however we want, basically, into those structures. Now, I've got a little caveat at the bottom there, and I don't know if you can see it online, so I'm going to say it very clearly. There is a different approach that applies for couples, and this does not cover relationship property. So if two people are in a relationship, or maybe in a relationship, and this is particularly important if they have not told anyone they're in a relationship, so maybe they haven't told their family, particularly in circumstances where they're either gay or some other factor that is stopping them from wanting to be open about their relationship. It is so important to make sure that your lawyer is in the tent with you, because we can't protect you and get the terms right unless we know the whole picture. So that's critically important, that these style of structures, they don't apply to relationship property. It has to be a relationship property agreement subject to that law, which I'm not going to go into further today, but certainly at some future point we will be going into. So Compliance obligations. Now, this is really unsexy, so I don't want to linger too long on compliance. But basically, we've got anti-money laundering and counter-financing of terrorism legislation, which is our AML laws. So professionals have to collect information about who you are and where your money has come from. That's the guts of it. It's not voluntary. It's not voluntary. It's compulsory. So any professional that you're going to get asked these types of questions. Don't fight it. Roll with it. And then we've got the bright line tax laws. Now, currently, we have a regime of different rules apply depending on when you purchased a property and when you're selling a property. So, but that law is changing, is the expectation. Now, our current government has indicated that those changes will take effect from the 1st of July. We've had indications, or we've had communication that it's going to be a 2-year bright line tax period, which means that from the 1st of July, if you bought your property longer than 2 years prior, then you will not be paying bright line tax when you sell that property. That is subject to the law actually passing. So my suggestion, and this is less relevant for buying property, but if anyone is listening in and is selling property, is wait until that law to pass before making any moves. That's critical. For you, if you're looking at buying, what you are factoring in is, if you are looking at buying an investment property, is it reasonable that I may want to sell within 10 years? Is it critical that I sell within 10 years? If it is critical and you don't want to potentially pay tax, then wait until the law to pass. If the purpose is just to get on with investing and you're not worried about potentially paying tax if you sell in 8 years and this law doesn't change, then crack on. But either way, just go in with eyes wide open and be wary that law is expected to change but hasn't yet. Last one there is overseas investment. So if you're buying property in New Zealand, all residential land is considered sensitive land under the overseas investment legislation. And that means that you have to be there's a number of categories, but the main ones are a New Zealand citizen, an Australian citizen, or a Singaporean citizen can buy property in New Zealand. If you are a New Zealand permanent resident and an Australian permanent resident, you can buy property in New Zealand. If you are a New Zealand resident and you are living in New Zealand, then you can buy property in New Zealand subject to some factors that relate to you being here at least half of the year. And I think there might be, I feel like there's one other factor that I've forgotten, but is easily Googleable. So the upshot is that if you're not a citizen of New Zealand, a quick search to make sure that you are able to purchase property in New Zealand is a good idea. But generally, if you are a resident and you are living in New Zealand, you're just living your life here, then you're going to be eligible to buy property in New Zealand. That's the crux of the situation. So now we're turning to actually how we investigate property, and this is kind of my golden standard, or the factors that when I'm looking at an agreement, when it comes onto my desk, these are the core things that I'm looking at. So first thing that I'm turning my mind to is the purchase price. And if I'm buying property, obviously that's particularly important. Is it the price that I want to pay? The deposit, which is usually going to be 10%, checking that I've actually got that right in the agreement and that I'm physically going to have that cash in the bank account to be able to pay the deposit when I go unconditional. So that's important. You might want to reduce the deposit if you only have 40,000 cash sitting in your bank account. You might want to specifically put 40,000 as the deposit rather than 10%. And vendors are generally amenable to different people's circumstances as long as there is seriousness with the offer. GST status is potentially critical. What it relates to, on the agreement, you're going to have plus GST or inclusive of GST. And if you're buying from a builder or a developer or some other GST registered entity, and the front page says plus GST, if you are not GST registered, then you're going to be adding tax onto whatever the dollar figure is that's written there. So if it's 500,000 plus GST, then it's going to be 500,000 plus whatever that GST is, 15%, 75,000. That sounds right. So it'll be 575,000 actual purchase price for you as a non-GST purchaser. So it should be right, but checking it's right is important. Settlement date. Have you got enough time? Is it right? Is it going to fit in with what the time frame of you wanting to settle? Chattels that are included. This is all the stuff that's not nailed down or screwed down. in the property. The general warranty is that anything that's included in that list is going to be in reasonable working order, but it doesn't need to be perfect, so dinged up, etc. It'll be in whatever condition it is at the date that you sign the agreement. So the most important thing is to check that everything that you're expecting to be on that list is actually on that list. So if you do a walk around the property and you're expecting the washing machine to be included in the purchase, and the washing machine is not in that schedule of items, it will not be there on settlement day. So it needs to be added in. Some examples that I've had are like wall mirrors that are not actually screwed on. They're just kind of sitting on a screw, and then they've disappeared for settlement day. The worst one I ever had was a bank of pots, plant pots, and the pots were not included in the chattel list. And on settlement day, all the pots were removed, and there was a dirt bank. So it can be important. It can be stuff that you would have thought is just included. So checking that it's right is a good thing to do. Conditions in the agreement, I'm going to put a bookmark in that because we're going to talk about conditions a bit more fully in a second. But further terms of sale is a portion at the back end of an agreement where anything weird, wonderful, unique about that particular purchase is going to be located. So if there is any exclusion of any of the standard warranties, if the vendor is saying, I haven't lived in the property for 10 years, I've got no idea whether the power works to the property, I'm excluding that warranty. I'm not saying that the electrical is all going to work. This is where it's going to be located. So it's a really good place to look to make sure that there's nothing, as I say, weird or wonderful going on with the purchase that you're going after. And then unit title disclosure is specific to unit title purchases. So this is additional information that you get if you're buying a unit title, and it's going to give you extensive information about that unit title development. So there's specific requirements in law now which has a laundry list of information, minutes from the body corp meetings, evidence of the long-term fund relating to maintenance. There's a whole bunch of information in there to trawl through and make sure that there's nothing out of the ordinary. A big one for those in apartment buildings is water tightness, because traditionally, say if I have a house, I'll own my house, and if my neighbour has a leak in his roof, it doesn't affect me. If my neighbour has done something that caused that leak in the roof, so he's run something that causes a whole bunch of moisture in his living room and has rotted out, things and caused issues, it doesn't affect me, it doesn't bother me because he's a totally separate building. In an apartment building, if my neighbour has done something that has caused issues to the roof, well, that might affect me because it might now affect my roof. It might now affect my shared wall with them. And even though they might be liable, you've still got to go through that process of forcing them to pay, forcing them to deal with it. And that might not be a walk in the park. So it's not just looking out for your specific little apartment, it's also looking at the bigger picture of the development to make sure that there's not bigger issues with particularly water tightness and weather tightness. And so that's stuff that's going to show up, actually in the documents. That's going to be there when you get the agreement, when you get the information from the real estate agent. But the other general investigation things that I'm going to be looking at are whether the vendor has done any work on the property. Now, the standard warranty in the agreement is that if the vendor has done work on the property, then they must have got the appropriate consents and sign-off from council. So that's the standard warranty. So if we're looking for weird and wonderful in our further terms, we might see something like the vendor installed a bathroom and the purchaser acknowledges that no consent was obtained and they're purchasing as is, where is. That's something that comes up fairly regularly. That's an exclusion of the general warranty that the vendor would otherwise have to apply. Now, if the vendor didn't do the work, but the last owner did the work and it doesn't have all the consents, the current owner is not responsible for that and you are just purchasing buyer beware. So looking at what work the vendor has done, looking at what work has been done generally is going to give you the picture to make sure that all of the alterations to the property have the appropriate consents and appropriate sign-off. So now, post 1993, we would call that code compliance, a code compliance certificate being issued for those works if it's required by council. So that's what you're looking for. Next up is property insurance. Make sure that you can actually get insurance for the property. My suggestion is to do that before you're locked into a contract, just in case there's something that would affect your insurance. And I would say that it's very rare that you can't physically get insurance for a property, but it's more common that some factor with the property will influence the extent of the cost and any exclusions or limitations that the insurance company puts on. So that's something that's important, bearing in mind that it's a requirement of every bank to have insurance for the property before you are able to draw down your lending. So it is important that it's done, and it's just whether you do it before you're locked into a contract or after you're locked in. Now, the healthy home requirements, these are different to the building code generally. So properties can be constructed and not be compliant with the healthy homes requirements, but they cannot be tenanted. So if you are buying an existing property, you want to be looking at whether the home is currently compliant, what you would need to do to bring it up to compliance, particularly in terms of heating, insulation, and the ventilation, the first three on that list there. And that's things like ventilation out of bathrooms, and whether it's going to be an issue putting those in, putting the ducting in. There's certain exemptions for concrete slab properties and for flat roof properties in terms of insulation. There's also, like if it's cinder block, then maybe you don't need to do wall insulation. So there is exemptions to the rules, but as a general principle, you want to make sure you understand the position so that you know that when you come to sell, if the property is not compliant with healthy homes, it might impact whether investors want to buy that property. So if you're buying a cookie cutter style property and it is not compliant with healthy homes, then you are limiting yourself to first home buyers, people that want to downsize, people that can't afford to have a unique or bespoke house, but you are taking anyone that wants to be a landlord out of your pool, or they are in the pool, but they will see that they have a cost associated with buying that property and they will factor that in when offering you money. So it's important to bear that in mind because it might impact what you ultimately can sell the property for.
Can they force you as a seller to get that heat pump installed?
Can they force you to get the heat pump installed? No, they can't force you to do it, but it can be part of the negotiation around purchasing and buying. So for example, a way of doing that would be, I'm happy with the property, but I'm going to reduce the purchase price by $5,000 because I'm going to put the heat pump in, or I'll pay you the full purchase price as long as you put a heat pump in before settlement. And so it just becomes part of the negotiation. Yeah. And again, I've reiterated because of the importance, checking those further terms in the agreement and making sure that there is nothing there. A little extra tip is that in the agreement there's a page, 18 or 19, that is the further terms page, but often it says see attached further terms, and then there's a page at the very back of the agreement that actually has the further terms. So if you're scrolling through an agreement and you get to that page and you're skimming and it's blank, just carry on reading just in case there's something at the back end of the agreement, because it doesn't have to be referred to in that schedule, it can just be attached. So make sure you read the whole agreement is the upshot. It's kind of like reading the back of the exam paper. Now, in terms of conditions, you can literally put any condition you want in the agreement. I could put in an agreement that my purchase of your property is subject to my dog reaching 15 kilos before Christmas, if I wanted to, right? So when people think of conditions, I think sometimes there's a bit of a narrow perception of what a condition is or isn't. A condition is simply, this has to happen for me to do X. And those two things can be anything. The lights have to go out for me to leave this building, right? That's a conditional statement. So our core conditions, the ones that we see most common, on the slide: finance, due diligence, solicitor approval, building report, limb report, and drug test or methamphetamine testing. Now, the most important thing with conditions is that you can only terminate a contract based on the conditions that you have. So if you have a finance condition and you get a building report, you can't cancel the agreement because you don't like what's in the building report unless you can't get finance because of it. So the reason for exiting the contract has to relate to the condition that you've got, as in you can only get out for what you said that you were waiting to confirm. The big place where I think there's some strong advocacy to be had is solicitor approval versus due diligence. Now, a solicitor approval condition is not the same as due diligence condition. If you're told bang in a 5 working day solicitor approval condition because it's basically due diligence and your lawyer can look over it. If they have any problems, then you can just cancel. That's a dangerous position to take, in my opinion. I would be far more comfortable with a 3 or 5 working day due diligence condition. You can make it tight so that the vendor has confidence that you're serious and that you're going to expedite your investigations, and that they're not taking the property off the market for too long. So if there's someone else that wants to buy, they can crack on and give them an opportunity. But it's basically a get out of jail free card. It's a I'm going to look at everything while you don't sell to someone else. So that's effectively saying I'm going to incur cost. You've promised not to sell to someone else whilst I incur that cost to investigate and make sure I'm happy with the property. That allows for the investigations that you need to take, and particularly a review to make sure that it's doing what you think it's doing, and then you can satisfy that condition and push on. A solicitor approval condition can be a bit limiting, and it does sometimes worry me, because we can only bring what I would consider to be objective problems with the contract. So for example, if you said, oh, we've found somewhere else and we want to put an offer in there, we want you to cancel the contract because we want out. That's something that probably is not within the scope of a solicitor approval condition. It's probably putting you on shaky ground that you've actually validly cancelled that agreement. And the reality is that me as your lawyer, I'm not the one that's carrying the potential risk and the potential liability. You as the purchaser who is attempting to terminate, you are carrying that risk. So definitely if you can sneak or if you can encourage a due diligence rather than solicitor approval, that's an advantage. And then in respect of building report and limb conditions, the building report is to assess the current state of the building generally. Now some inspections will include the review of the council file as part of it, as an extra. But generally you're looking at the current condition of the building. How is it now? Does any work need to be done? Are there any issues? The limb report is looking at the council file and determining a number of things, but mainly have the consents been obtained and the appropriate sign-offs. So was the building meant to be compliant with the law based on the plans, and did it get constructed in accordance with those plans? So that's what you're going to find out in the limb, whether there's a record of that with the council. And you're also going to find out whether there's any special land features. So, for example, in Tauranga, we're blessed with a beautiful beach, and any property that's in Papamoa will have on its special land features a tsunami warning as part of its council file. Now, when I tell that to clients, no one goes, oh my God, I can't believe that it's in a tsunami zone, because obviously it's in Papamoa. So it's not a shock, but it's still helpful information. And there's other things in there like flooding information. And again, you would go, oh yeah, Papamoa, low-lying, flooding. But depending on the way the roads have been created and depending on where the draining is, actually dictates where water has been designed to flow. So the property you're looking at might be right in an area where in a 1 in a 100-year event that it will flow over your front lawn by design. So that's helpful to know if you're going to build your garden shed in that lawn, or if you're going to put a $20,000 bespoke golf green in your lawn that is designed to get flooded every time there's a major storm. So that's something that's relevant. The two are not the same, is my point. So when you're doing your due diligence, you should see them as separate, and if you are doing a full due diligence check, then getting both is the best way to go. All right, now when you're buying, when you're selling, this is one of my biggest frustrations with people when they're selling and buying is not getting the agreements to talk to each other. It's so easy to do if you have the agreements reviewed and checked before you sign. So whether it is your lawyer, whether it's your accountant, whether it's your best friend, someone that is able to compare those two contracts and make sure that particularly the conditions and the settlement dates are lining up. So you don't want to be, for example, locked in to a purchase and your sale fall over. Because then you won't have the money to complete the purchase on the property. You don't want to have a settlement date on your purchase that is a week before your sale, because you won't have the money yet to pay for your purchase. Unless, under finance, you're going to do what's called bridging finance, or you're going to go to your bank and you're going to say, hey, look, we're purchasing and we're selling. We want to purchase on the 1st of the month and sell on the 14th of the month so that we've got a fortnight to move all our stuff into the new place. And then you're asking the bank to basically advance extra funds, a bridging loan, to get you over that fortnight. And so they go, oh yeah, that's fine because we know you're going to sell, we know you're going to pay us back, and therefore you'll pay for the pleasure with high interest rates and fees, but you'll get the benefit of being able to have that fortnight to be able to move your stuff over. It's not available to everyone, but it is there as something the banks might do, and it just depends on your particular circumstances. So that conversation with the bank comes out of making sure that you understand how the two agreements are talking to each other, that you've got those dates, not necessarily on the same day, but they're working in harmony, they're lining up so that you know the plan. And the worst cases that we deal with are when the dates are round the wrong way or not lining up. And then penalty interest, and depending how bad it is, it could be that you lose one of the contracts or both of the contracts. So it's relatively easy to mitigate if it's dealt with at the front end, rather than dealing with it on the fly. The other important thing with buying and selling is the deposit. Now, what I get a lot of the time is people having in their mind that if they sell, say you sell for $900,000 with a $90,000 deposit, that when your sale goes unconditional, that day you're going to get $90,000 into your bank account and you're going to be able to use that $90,000 to pay the deposit on your purchase. That's generally not how that plays out. And one of the key factors for that is that there is a time frame that's allowable for when a deposit is to be paid. So the deposit isn't necessarily paid the day the agreement goes unconditional. It could be paid 3 days later, which means that you haven't received your funds to be able to pay your deposit. So there is a bit of wiggle room around when that money comes in. And secondly, generally the money goes into the real estate agent's third-party trust account, and when the money is released to you, the commission is deducted. So your $90,000 actually comes out to you at $55,000 because the agency has taken their fee, and then you've now got the balance. So the upshot of that is make sure that you understand your cash position to pay your deposit, because you might not have the deposit from your sale to pay it. And that's where, when I talked about earlier in the chat about if you've got $40,000 cash in your bank account, then that might be what you make available for the deposit when you go unconditional, and that you're not actually able to use your sales deposit yet because those funds won't be available at the time when you need them. So again, thinking ahead, coordinating is going to be your friend, because when you go unconditional, the agreements, what I would say, crystallize, you're locked in, and whatever dates, whatever provisions are there, that is what will happen unless everyone agrees. So if once you're locked in, people don't agree to a change of those dates, whatever the default dates are, that's what it's going to be. So as much as possible, making sure those are correct, that's going to put you in better stead to make sure that you have a smooth and safe settlement process. And that's kind of a snapshot, quick, hard, focused summary of buying property in New Zealand. So thank you for tuning in online. It's been great to have you, whoever's been there. And we're going to have a quick Q&A. So the initial thing that happens is that if you can't do if you're, say, unconditional and you can't settle because you don't have the money at the right time, then penalty interest and costs. So penalty interest at a fixed rate, it's normally 10, 12, 14%, somewhere in that ballpark. And that's calculated daily. And then costs. So legal costs, if a party is having to carry their mortgage while you're in default, then you might be liable for the mortgage costs as well. It can quickly rack up, but it also, if you are out by a day or two, the right to cancel, which is the next remedy, that is 12 working days from the date of default and notice. So you go into default, the other party says, hey, you're in default, you need to settle in 12 working days or we can cancel. And then you've got 2.5 weeks to figure it out and get the money to be able to settle. And if you don't, then the other party can cancel, or they can go to the courts and start getting more aggressive with their position. So you've kind of got this 2.5 week window where you're going to pay for the pleasure, you're going to incur the costs of penalties, but the other party can't yet cancel. So on a $700,000-800,000 purchase with an interest rate of about 12%, your daily rate, you're going to be looking at about $200, $250 per day in penalty interest. So if you're out by 2 days, then you're south of $1,000 in costs, but then still being able to settle in full. So it's not the end of the world. It's just costing money and stress and unnecessary, basically. So yeah. Understanding whether the property is vacant or not, I think that's a good one, and that's less of a legal thing and more of a practical thing, because if it's a mortgagee sale and there's still someone living in the property, then they may be septic, they may not have a normal vendor's attitude to the sale, which means that although you might have the legal ability to get a reduction in purchase price if they do something silly, you would still have to deal with that silly thing that they've done when you take over the property. So I would say that's probably number one, would be like understanding whether there's a problem person still involved. But generally a mortgagee sale, they're going to have, in the further terms, they're going to have limitations that it's as is, where is, and that all the normal vendor warranties don't apply. So doing the investigation is more important to make sure that you know yourself where the property is standing, because the vendor won't have any obligations necessarily to make sure it's to a certain standard. And I didn't clarify myself as well as I should have. That's really if it's only for reviewing the contract, reviewing the title, as a direct replacement for solicitor approval. Yeah, finance, LIM, building report, 15 working days. Yeah. Yeah, certainly. Because if you're getting finance approval, I don't even think 10 working days is enough these days. It's just that the cogs move slow, the requirements are extensive. So 3 weeks is reasonable. And then LIM reports, the time to get a LIM report is for most councils around 10 working days. So then you need time to get it and then time to review it, basically. No, but it depends. Depends on when in the month you're talking to the bank. It depends on what they've had for breakfast. It depends on what colour the sky is. You know, every bank has a different policy to riskier or to all their lending, right? They have different policies, and then they have different things that they want to focus on. When it comes to new builds and build contracts, each bank will change over time their specific requirements. The best people to nail that for you are mortgage brokers, in my opinion. Mortgage brokers are free. They are financial advisors caught under the financial regulations that govern financial advisors of their category, which means that they have obligations to a higher regulatory board, which you can enforce against, which is ideal. It's same with lawyers, like practicing lawyers. You know, we're bound and we're governed, so you can complain about us, which is a great mechanism, a self-regulation. But mortgage brokers, they're knowledgeable about finance. They're connected in with the banks, the good ones, so they understand the policies as they're changing. They understand better than, say, me, what the banks are doing and when. They're not all created equal. Find a good one and use them like you would use any resource. Use them like you don't pull your own teeth, you go to a dentist, right? You get a specialist to do the job. That's how I would suggest using mortgage brokers, because if you go direct to the bank, you're getting one product from one person, which is the equivalent of going to Rip Curl to buy a wetsuit rather than going to Mount Surf shop and looking at all the different brands of wetsuits and picking the one that's right for you. So rather than that kind of, looking at all the different options, you're just getting one given to you, and they are going to tell you that what they've got is the best. And we've all had that in retail. So we know what that feels like when you're told that this is the best option for you, and then you go online or you go to a different store and you're like, that's crazy that they were telling me I should have done that. This is clearly a better product. So yeah, that would be my big suggestion on the finance front, certainly. Well, yes, we do have different options available for first-time buyers, and generally just for buyers that don't have a 10% deposit. So banks are governed by legislation which restricts how much lending they can do in that more risky space of low equity, like low cash, high lending, which is your, say, 5% deposit, 95% lending, 10% deposit, 90% lending. These are high risk areas for the bank. So in terms of being able to get around needing a 10% deposit, we've got being able to pull out your KiwiSaver withdrawal to go towards your deposit. We've got the first home grant, which is that if you are under certain income thresholds and you're buying a property under certain thresholds, depending on what city you're living in, then you can get free cash money up to $10,000 per person for a new build. So if you're a couple, you can get up to $20,000 towards your deposit. And those all then go into as cash as part of then your deposit for the purposes of getting your bank loan. So generally speaking, if you're buying property, you're going to be aiming for a 10% deposit anyway, but there are kind of those extra things to be able to assist with buying. And next month, we're actually going to be doing first home buyers, and we're going to be and so that's going to be the topic for next month. And we're going to deep dive into those exact things, so the things that are unique to people that are buying their first home. Yeah. So the point when you actually pull the trigger and get insurance is once you're unconditional. The point when you should investigate insurance is before you're unconditional. And that's just to make sure, there's a couple of options there actually. Because it's going to be a requirement of your finance that you get insurance, you could just do it that you have a finance condition, and then you look at insurance while you're organising your finance. Now, one of the limitations on that in the current market, where there is not buyers out the door and prices aren't going crazy, is that if you physically can get insurance that would be satisfactory to your bank, there's an argument that you cannot cancel on the basis of insurance that you're just not quite happy with. And therefore your finance could be approved, and therefore you should satisfy your finance condition. So anytime you are using a condition in a subjective way, there is risk that the other party will say, no, you can get finance because you physically can get insurance. It's just not exactly what you would want. Or it's an extra $50 a month. Or the boundary fence down the bottom of the hill is excluded, or whatever it is. You're kind of bouncing up at that. So the best way to protect yourself is to check before you're locked in, or have a specific insurance condition that the agreement is conditional on you confirming that you can get insurance. Yeah. But generally, you will hopefully have an indication of whether you might have trouble with getting insurance from the real estate agent, or from the vendor, or just from your walking through the property. And it's one of the questions to ask the real estate agent. Has the vendor had any issues with getting insurance? Does the vendor currently have insurance? Who is the vendor's insurance with? Now, some of those questions might be subject to privacy. Some of them might mean that the agent says, no, sorry, I can't answer that. But your job as a purchaser is to ask as many questions as you can, to ask everything that you can about the property, about the history, about the neighbours. Have they had any problems up the road? When was the last time it flooded? Have they repainted? When did they repaint? Was there any mould when they repainted? Has there been any moisture under the carpet? When was the joinery redone? Were there any issues when the joinery was redone? All these questions, it's just a case of trying to learn as much about the property, because that's your friend. Because then with that knowledge, when you go in and you get the builder, and the builder does the building, not the builder, sorry, the building inspector goes in and says, oh, there's a high moisture reading in the third bedroom, and you go, oh yeah, the agent mentioned that 2 years ago they had a burst water main, and that they had redone the pipes on this wall, and so a high moisture reading is suddenly potentially a major problem, because it's an indicator that whatever they did didn't work. So it might not be that it's just a cold winter's day and that therefore you got a rogue high moisture reading. It could be an indicator of a major problem in the wall. So that piece of data, together with your kind of investigations and your questions, is going to give you a better picture. And perhaps I don't know if I'll get into trouble with agents with what I say. My dad was an agent, so I feel like I've got this kind of joker card that I can just say whatever I want. But basically, agents, if you look at it, that the vendor is the client and the purchaser is the customer. That's the way I like to visualize it in my mind. So the vendor is trying to sell the property the agent is trying to sell the property for the vendor. That's the client that they're trying to make money for, right? And they're trying to sell the property to the purchasers. And the way that we've structured our law in New Zealand is that they owe a duty to the purchasers, because purchasers are deemed to be vulnerable in that relationship. So it's not acceptable, for example, it's not acceptable that an agent would know that there is no code of compliance for the conservatory that's been built, and that they wouldn't disclose that to a purchaser, right? So as soon as an agent is aware of a problem, as a general principle, they are required to disclose that to purchasers, because as a rule, we've decided that we don't like it that agents would be able to withhold information from purchasers. So there's a nice boundary there. The bigger problem actually comes with the vendor and the purchaser, that the agent has really strict legislative obligations on them based on what they know, but the vendor doesn't have the same obligations on them. The vendor and the purchaser, it's more of a buyer beware relationship. And that's where the questions come in, because the vendor cannot lie point blank, but they can not say things. So if you just haven't asked the question, then a vendor might be able to get away with defects on a property that if you had asked them and they had lied to you, then they would have been liable for. So questions about water ingress, those are big ones that you put to the agent, but if you can, to the vendor as well. Have you painted recently is a good one, because often painting and stopping is a way of covering up water damage. And so it might be that a property in the winter had some water damage, and then it's aired out in the spring, and then by the summer it gets stopped and then painted, and then the moisture readings show up as normal, and then it's put on the market and sold. And that's a really naughty thing to have done, and I'm not saying that everyone does that, but it does happen. So it's just certainly need to make sure that you're asking about stuff. But to come back to your question, the agents are generally obligated to disclose what they know, and then they put that on their property owners to tell them everything they know. So the listing agreement with the agent and the vendor is going to have a whole bunch of disclosure that the vendor has to give the agent, and then hopefully they're going to be passing that information on to the purchaser.
So a good question to ask the agent, is there anything else you should be disclosing to me?
Yeah, correct. Is there anything wrong with the property I need to know about? Are you aware of any issues? Have you read the LIM report? Did you see any issues in the LIM report? Have you read the building inspector's report that's in the bundle of the auction pack? Was there anything in there that caught your eye? These are all questions that the agent could turn around and say, hey, that's a question for your lawyer. That's a question that you need to investigate. And really the worst case scenario is that that's exactly what they say. That they say, I'm not obligated to answer that question, or I don't know and don't have the expertise, and you have an obligation to seek that answer from your own advisor. And that's kind of, I think when you're getting, if you ask the agent 5 questions in a row, this is not a calculation, but if you ask the agent 5 questions in a row and they say that to every single one of the questions, you've got to the outer limits of the information that the agent is prepared to give you without you getting it yourself. And that's a good indicator that you can move on to the rest of your investigation. The short answer is no, that they don't necessarily. They don't necessarily say that the offer hasn't been accepted. Yeah, yeah, yeah.
As a purchaser, you need to tell your lawyer it's all over, right?
Yeah, yeah. And because, there'll be, like if I get busy and I've maybe had a spat of reviews of properties and then given those reviews to clients and said, here's the review, good luck with your offer or good luck with what you're doing, and I don't hear anything for 2 or 3 weeks, then the presumption is that it didn't go anywhere, you know. But it's not until confirmation. So we won't get actual confirmation directly. Yeah. Often I get people saying that they went ahead with putting in an offer or doing whatever they're doing because they couldn't wait for their lawyer to, or they didn't know how much it was going to cost, or the last time they got a bill from their lawyer, it was $1,000 or $2,000 to just look at a property for them, or it took him 4 days to come back to me and someone else got the property. So time and money, right? They tend to be the 2 reasons that I get regularly that people don't do the full due diligence that they maybe should. So the things to ask your trusted legal advisor are, how long does it take you to turn around a review of a property if I email you the contract and the details? And what is it going to cost for a standard review of a property, and will you give me a fixed fee to do that portion of the job? Those are 2 really good questions to make sure that you've got clarity on, because if you know from your advisor that they will guarantee a turnaround of 48 hours on a property review and that the cost will be $400 plus GIST and any searches of titles, then that information equips you that then when you're negotiating, you can front foot that with the agent or the vendor, and you can say, look, I need to run this past my lawyer, but give me 48 hours because I know that I can be ready to go in 48 hours. So whatever answer you get back from your advisor is going to equip you to then decide, do I do that due diligence and incur that cost, or do I just risk it and go ahead? And that's really valuable information for you to have and not just be going in blind. So that's what I'll end on. Thank you for watching, and I hope that you've managed to pick out a few key pieces of information that are going to help you on your property purchasing journey here in New Zealand. Today, Simon says, if you've enjoyed this video, give it a like. Subscribe to our channel so you can stay up to date on future videos on other areas of law. And if the conversation has sparked a thought that's worth sharing, leave it as a comment. I look forward to bringing you future chats, and remember, at LOA Law, we are good lawyers for good people.